What's up, beautiful people? So, we are now going to continue with our study of the Sixth Amendment cases here. We've gone through Powell versus Alabama and Norris versus Alabama, the two Scottsboro Boys cases. I've also looked at Betts versus Brady and Gideon versus Wainwright, and then we took a brief look at the one Maryland case that we're studying. Gotta love the MD, baby. The one Maryland case was DeWolf versus Richmond, which allowed for the provision of attorneys at bail review hearings, or what we call the initial appearance, or the commissioner's hearings in the state of Maryland. As we know, that is not a national pattern at this point, but it is the type of thing that I see personally within the next 5 to 10 years being an issue that raises to the Supreme Court and then becomes kind of a national pattern. We see this expansion of rights from the times of the Scottsboro Boys cases through Betts versus Brady to Gideon, and then so on and so forth into expanding one's right to counsel under the Sixth Amendment. So if that trend continues, then I envision that a case like DeWolf versus Richmond will eventually rise to the Supreme Court, likely, as we know, out of one of the southern states, as is what often happens with criminal issues. And then we'll make a determination that people will have a right to appointed counsel or counsel paid by the government in bail review hearings. So there's a couple more cases to finish out our case chart before we move forward into the test, and then maybe do a little bit of a deeper dive into Gideon. We have in re go. So in re means something in law Latin, like in the matter of. And we're talking about this guy, Gerald Francis Gault. Now, it looks like Gault, Gault, pronounced Go. And Gerald Francis Gault, he's a 15-year-old. This happens in the 60s and ends up argued by the Supreme Court in front of the Supreme Court in 1966. He's 15 years old. He gets taken into custody for making an obscene phone call. So what does that mean? He's breathing heavy into the phone. Maybe making some sort of sexy talk to some old lady on the phone. Okay. He had previously been placed on probation, so not a good kid necessarily, but, this is not a serious crime. The police don't notify Go's parents who are at work when they arrest him. So he's making these obscene phone calls. They don't notify the parents. And after the proceedings before a juvenile judge, Go gets committed to the state industrial school until he reached the age of 21. So there used to be these state schools that were the types of places where, it's kind of like a juvenile detention center, but there was also a little bit more like a work camp, kind of rehabilitative, but not really. And he gets sent there until he's 21 years old. And the question is, was this a due process violation? Does this violate his rights if he is essentially brought before a judge and then committed to the state industrial school without his parents being notified? And the court says, no, that's absolutely a violation of his rights. The juvenile court, in their actions without having the notification of the parents, have violated his rights. And through the 14th Amendment, they apply these rights to the states. We've talked about that with the incorporation doctrine and how that works. That's how the 14th Amendment is used as the vehicle to apply the Bill of Rights to state laws and state crimes. These requirements included adequate notice of charges, notification of both of the parents and the child of the juvenile's right to counsel, opportunity for confrontation and cross-examination at the hearings, and adequate safeguards against self-incrimination. The court found that the procedures used in Go's case met none of these requirements. Let's outline each of those, right? A juvenile has a right to an attorney, has a right to confront those witnesses against him, and has a right to adequate safeguards against self-incrimination, which includes, obviously, your right to have your parents notified. So that's in re go. Uh, Quite simply, juveniles, they have a right to an attorney, they have a right to cross-examine and confrontation, just like any adult, and they also need to have their parents notified before any of these proceedings take place. If you're under the age of 18, a parent or guardian must be notified and must be involved before any criminal procedure can take place against you. Otherwise, it's a violation of your due process rights.